Okay, good afternoon, everybody, and welcome to Rix Kay and JM Finn's webinar, where we'll be discussing estate and investment planning. Just a quick introduction from me before we pass over to our speakers. A little bit about Rix Kay. We are a full-service commercial law firm. We have a private client practice as well, where we look after business owners, entrepreneurs, and individuals, and we have offices across Sussex and Kent. JM Finn are a national and trusted firm of wealth managers. And just to let you know that the webinar is being recorded and we will host a Q&A at the end of it. As I said, welcome to our speakers. All of their contact details are there, and their contact details will be shown again at the end of the presentation. If you do want to contact any of them, they will be more than delighted to take your call and answer your particular questions. So without further ado, I'm going to pass over to our first speaker this afternoon, who is Bruce Clarke.
Good afternoon, everybody. For those that don't know me, my name is Bruce Clarke and I'm a partner with Rix Kay's private client team. So why is it important to consider estate planning and tax planning now? One of the things that we've seen since the start of the pandemic is that clients have understandably wanted to get their personal affairs in order. And although most of the press coverage of the financial impact of the pandemic has been rather gloomy, the financial impact, and in particular the resulting drop in values of portfolios, property prices, etc., does present people with an opportunity to undertake tax and estate planning now, whilst reducing the potential exposure to a larger tax bill in the future if they did so. One other thing that we need to keep in mind is that the government has had to pump a tremendous amount of money into the economy. And whilst I think it's fair to say that this was unavoidable, and without doing so, the effect of the pandemic on the economy could have been disastrous, these measures will need to be paid for at some point, and it is quite possible that tax hikes or changes to the various tax regimes will be introduced at some point to boost the Treasury's coffers. Andrew, who you'll be hearing from in a bit, and I were talking about this a couple of weeks ago, and whilst Andrew quite rightly made the point that overall inheritance tax and capital gains tax raise smaller sums than the likes of income tax and VAT, inheritance tax and capital gains tax changes are less risky politically. No party is going to win very many votes with making significant hikes in income tax, for example. One also has to bear in mind that back in July 2019, the Office of Tax Simplification published a report which looked at simplifying the inheritance tax regime overall. And although it is purely my opinion, and it may be I'm barking up the wrong tree, but to me, there is a real risk that the Treasury may use the need to raise funds to finance the emergency measures that have been introduced as an opportunity to introduce some changes to the inheritance tax regime and CGT regime that would otherwise be much more difficult to do so politically. So with this in mind, I wanted to quickly touch on some of the reliefs and tax planning opportunities that are available now and how they work. I'm afraid that this is going to be a bit of a whistle-stop tour of only a few of the reliefs available, as I've only got 15 minutes or so. But I'm very happy to look at particular situations and opportunities if anyone would like me to do so at any point. So the first of the reliefs I would like to look at are business property relief, or which I'll call BPR for reason, agricultural property relief, or APR. They are now generally shortened to business relief and agricultural relief, but I was brought up with BPR and APR, so forgive me for that. BPR and APR effectively operate to reduce the IHT charge by either 50% or 100%, depending on the nature of the asset. For example, shares in an unquoted company, shares on the AIM market, which is what Andrew will be looking at in a bit more detail shortly, and an interest in a partnership all qualify for BPR at 100%, provided certain conditions are satisfied. Broadly speaking, the person needs to have owned the asset for more than 2 years, and the shares or the partnership doesn't need to be trading, it's not a holding company. APR works in a very similar way. For example, land owned and farmed by the same person generally gets 100% relief. Now, a very common estate and tax planning technique is for assets that qualify for APR or BPR to be put into a discretionary trust, which can be done during a person's lifetime or as part of estate planning, tax planning undertaken when writing a will. What this does is it allows for the assets to be passed down for the benefit of future generations without incurring a charge to tax, and whilst also allowing the person undertaking the planning to retain some control, particularly if they are appointed, for example, as a trustee. Now, the creation of such a trust is a disposal for CGT purposes, and in theory, therefore, a charge to CGT does arise. However, any gain can be held over, so that essentially this is passed on to the trustees, who in turn can pass this on to the beneficiaries when the assets within the trust fund are pointed out. And with a bit of careful planning and utilising allowances or reliefs that may be available to both the trustees and the beneficiaries, it is possible over time to wash out that gain. Now, there have been suggestions that if the Treasury does make changes to the IHT regime, the Treasury may look to reduce the rates of relief or limit them even further. Business property relief as a relief in itself makes sense, as it allows individuals who own interests in businesses which are often unquoted and therefore difficult to sell or trade to pass these interests on tax-free without creating a tax bill that could potentially be difficult to meet. And obviously the same principles apply to APR and particularly farmland. BPR in particular was one of the tax reliefs that the Office of Tax Simplification picked up on in its report and focused on in quite a great level of detail. But interestingly, some of the changes they did propose actually potentially allow for greater planning going forward, because potentially holiday letting businesses would be able to claim the relief. But that's a topic that's quite in depth and is probably a topic for another webinar for another day. The other thing I wanted to look at is straightforward gifting, or what I would call straightforward gifting. Straightforward gifting is really, in my opinion, one of the most underutilised opportunities available to everyone to minimise their exposure to inheritance tax. There are, of course, certain restrictions and certain limits, but it's by far and away one of the easiest methods of getting assets out of an estate, and if done as part of lifetime planning, carries the added benefit that the person making the gift can see the recipient enjoy the gift, rather than waiting for the recipient to receive the gift following death. Now, obviously, this needs to be done as part of careful planning. As I said, there are limits on the tax-free elements of gifts, depending on the nature of the gift and other gifting made previously. But as part of a regular strategic review, these gifts can be woven into a client's estate and tax planning with very effective results. Now, the starting point when looking at gifting is that the donor, i.e. the person making the gift, has to survive 7 years for the gift to fall outside of their estate. The rules are a little bit more complicated than that, depending on the nature of the gift, but it's a good starter for 10. However, there are other rules which are often underutilised that allow individuals to make gifts without these counting as part of that 7-year clock. For example, every tax year, every individual is allowed to make gifts totaling £3,000. Therefore, for example, grandparents who had six grandchildren, could give between them £1,000 to each of the grandchildren every tax year without potentially incurring a charge to IHT. Another option is for those with excess income to potentially look at gifting that excess income away now. And again, this is something that's very effective, but is very often underutilised. Essentially, if an individual's income is such that it exceeds their annual expenditure, it is possible for that person to gift away the excess income without any further tax consequences. However, it is important that the gifts of the excess income don't have an impact on that person's standard of living. And whilst the gifts don't have to be the same amount each time, because it is accepted that everyone's income and expenditure fluctuates as time goes on, it is important that there is some regularity to the gifting. Now, I do appreciate that this exemption may not appeal to everybody and possibly isn't suitable for everybody. For example, a younger person may be better advised to consider topping up pension contributions and claiming tax reliefs available there. However, conversely, someone who has retired and who has a good level of income and a lower level of expenditure may be better placed to utilise this exemption by making gifts to people that they may not otherwise be able to do so. Again, enjoying the added benefit of seeing the recipients enjoy the gifts during their lifetime. Because of course there's not a lot of point capitalising excess income only for it to be potentially taxed at a later date. Now, one of the other questions I'm often asked is, can I give away my home to my children but continue to live in it? The answer to that question is yes, but it's not as straightforward as that. As I'm sure you can imagine, over the years, HMRC have got very wise to various schemes that have been concocted to achieve this, and some schemes are still out there and work, whereas there are a lot of schemes that have been shut down by one means or another. My mantra is very much keep it simple. It's possible to simply gift away part of the family home to children, but this does need to be structured in the right way to avoid any reservation of benefits and the gift not counting as part of the overall planning. So, as I said at the start of this slide, outright gifting is without doubt one of the simplest ways of undertaking some tax planning, and I've really only covered a couple of the exemptions available here, as I haven't got time to go through them all. However, again, the 7-year rule and the various exemptions that we have looked at did feature in the Office of Tax Simplifications report, with proposals that, to be fair to them, would have simplified the nature of the gifting regime and exemptions available, but the proposals would have also, I should say, potentially result in greater tax increases overall. So, having touched on a couple of reliefs and exemptions available, and as I said earlier, there are a few things we haven't had a chance to look at. How does this all fit in with where we find ourselves today? As I said earlier, I think it's fair to say that many people have seen falls in values of assets as a result of the pandemic, whether it be portfolios of investments, for example, or properties, investment properties. One would hope that whilst there will be a return to pre-pandemic levels at some point, and the FTSE, etc., has seen a bit of an upturn already, whilst values are at their lowest, for those who do want to undertake some estate or tax planning, now is a time to do so, using those lower values to their advantage. So, to demonstrate this, for example, imagine we have a couple who we will call Mr. and Mrs. Bloggs, which I know is very original. Imagine Mr. and Mrs. Bloggs have 3 children, and as you can see on the slide there, they've got an investment portfolio, which was worth £1 million before the pandemic. They've also got 2 investment properties worth £250,000 each. Their own home is worth £450,000, and they've got £100,000 of cash in the bank. So for our purposes, imagine they're in their mid-50s and want to start thinking about longer term planning, which we would certainly have been advising them to start doing now, as the value of their assets overall are such that we're creeping up towards the threshold for the residence nil rate band starting to taper away anyway. So let's assume as part of that advice, and as part of the result of the pandemic, there's been a fall in value of their assets of say 10%, and we can see there the impact that this has had on their net worth. So as part of that, Mr. and Mrs. Bloggs want to gift to the children one of the rental properties and 20%, say, of the original value of the investments. However, they want to retain control of the management of those properties and the investments, as they've got some concerns about their children's partners. This is a scenario that we are often presented with, and in fact, it seems to be presented with more and more these days. So how would we deal with this? Well, In such an instance as this, we would probably look at creating a discretionary trust, which would allow Mr. and Mrs. Bloggs to retain control of the assets, but not benefit from them. The creation of the trust would be a chargeable lifetime transfer for inheritance tax purposes to the extent it exceeds the nil rate band, as there are with these assets no exemptions available. And on the basis that the figures we were talking about would not exceed their individual nil rate bands, there should not be a charge to IHT on the creation of the trust. And just as an aside, we would probably look at creating two trusts to minimise the tax exposure of the trusts themselves going forwards. Now, pre-pandemic, the value of the transfer would have been £450,000. However, as a result of the fall in values, the value of the transfer is actually now £380,000, so therefore a reduction of £70,000 and a reduction in the potential tax saving based on the original figures of £28,000. One also has to bear in mind, of course, that the increase in value in those assets, once things start returning to normal, hopefully, will of course fall outside of their estate and will form part of the trust. Now, the obvious thing here is to simply consider whether or not Mr. and Mrs. Bloggs can afford to put more into the trust, i.e. the actual figures they had originally intended, rather than the number of investments, for example. Again, using those lower values to their advantage, getting more out of their estate now, and then potentially the growth going forward, getting that out of the estate now as well. So going back to how this fits in with where we find ourselves today in my original comments, it is, in my opinion, quite probable that at some point changes to the various tax regimes will be announced. What these will be, we will have to wait and see. But again, in my opinion, it's quite possible that these will include changes to the inheritance tax regime, which may result in greater charges to tax further down the line. With this in mind and the falls in value we've seen, or experts are anticipating seeing in particular, now is the time to have a look at individual circumstances and whether it is possible to undertake any estate planning or tax planning now, whilst we know what the rules are and whilst we know what we are dealing with. The final point I would like to make before I hand over to Andrew is whatever planning is undertaken, going back to my mantra, keep it simple. As I mentioned earlier, there are a number of tax planning schemes out there, some of which have come under the spotlight in recent years, and HMRC do seem to have an ever increasing dislike of schemes and things that, should we say, artificial things that are put in place to create the intended reduction in tax. The simple methods work. They're tried, they're tested, and in my opinion, although there is a risk that they will be looked at, they're probably less likely to be as aggressively attacked by HMRC and the Treasury. We have seen the Treasury in the past introduce legislation which has targeted specific schemes or arrangements, all of which, of course, is much easier politically to do than pass legislation which targets standard tax planning techniques. So if you are considering undertaking any planning at the moment, start simple. That's the biggest thing at the moment, I think. Hopefully that's given everyone some food for thought. I'm very happy to answer questions at the end or on an individual basis later on. If you've got any questions, by all means, do feel free to email me. But I'm now going to hand over to Andrew for him to look at AIM shares in a bit more detail, which, as I mentioned earlier, qualify for business property relief. So over to you, Andrew.
As Bruce said, I'm going to talk a bit about achieving business relief on AIM and give you the background to the AIM market and how we go about it. So next slide, please. So the AIM is currently celebrating its 25th birthday, having been launched in 1995. And I was there at the start, investing in some of the very few AIM shares. I think there were 12 shares that were listed back at the start in June 95. And then business property relief was introduced on AIM shares in 1998, at which time I launched one of the first, if not the first, services involved in running IHT portfolios whilst I was at a company called Singer and Friedlander. So I've been doing it a long time. There are currently around 800 companies listed on AIM, which is actually a reduction from where it was a few years ago, largely because the regulator, the FCA, has been weeding out some of the weaker companies and advisors. So the quality has definitely improved, and the average size of company listed on AIM has improved. So far, over those last 25 years, the companies collectively have raised about 117 billion, so a pretty substantial sum. And the current market cap, as you can see, is about 98 billion. And generally, AIM is regarded as being one of the most successful growth markets in the world. Next slide, please, Scott. I think the key points on this slide really are that AIM stocks became eligible for ISAs back in 2013, which is obviously quite useful. It means that clients can convert their existing portfolios within ISAs into an IHT efficient ISA, which is pretty compelling. And then also stamp duty on AIM shares was abolished back in 2014. So again, it's relatively cheap to deal in AIM shares. Next slide, please, Scott. I think this slide really talks to the point I was making about the reduction in number of companies and the resultant increase in quality of those companies. But it also demonstrates that there's a lot of trading that goes on AIM, and therefore it is reasonably liquid. Next slide. So IHT, I'll skip over this slide fairly quickly, but it was originally launched or started as inheritance tax, at least in the mid-70s, and has steadily increased the yield or the funds raised for the Treasury since that time. Next slide, please. Last year, inheritance tax receipts were about 5.1 billion, and they've grown steadily over the last 10 years by about 11% each year. So the take is increasing, but actually it's still relatively modest. It's, in fact, as you can see there, less than 0.25% of the annual tax take that the Treasury keeps or gets each year. So not very significant, as Bruce mentioned. You know, compared to income tax or VAT, it's a drop in the ocean, really. Next slide. Again, I'll skip over this one fairly quickly, but IHT is obviously paid at 40% when it's above the threshold, which everyone has, of 325,000. Next slide. So business relief, or business property relief as it was formerly known, was introduced in the mid-70s to allow family companies to be passed down through the generations tax efficiently. And it was extended to AIM shares, as I mentioned earlier, in the late 90s. So it also applies to those AIM listed shares that qualify. Not all AIM shares qualify, although the majority do. Those that don't are things like property companies or a company that has a dual listing. So maybe it's listed on NASDAQ or in Dublin or something like that, and that would disqualify it. Next slide. And then as an individual, to get the relief, you need to own the shares for a minimum of 2 years. And importantly, you need to still own them at the point of death. So it's no use just buying the shares, holding them for 2 years and then selling them. You need to retain them. But the good thing is about the legislation is that we can make changes within our portfolios without restarting that 2-year clock. So if I think a share is overvalued and I want to sell it and move on to something else, I can do so without upsetting the client's IHT relief. Next slide, please. So they've, as I mentioned earlier, about 800 companies listed on AIM. I follow, I reckon, around 250 of them. And when I say follow, that means I have meetings with management, generally at the moment by video rather than in person. And then I have a watch list of about 65 or 70 companies from which I select the stocks to make up our inheritance tax portfolios. Now, how do I select those is, I hope, on the next slide. So yeah, what we're looking for is established, profitable, financially strong companies that generate cash, pay dividends, although that's a bit of a moot point at the moment because a lot of companies have suspended their payments during the pandemic, but I'm sure that will return to normal before too long. And then above all, the company must have a strong management team. So I spend a lot of my time meeting those managements, getting to know them, understand their strategy, and really get under the skin of the business and the team to ensure that the company has a good prospect. So the way we specifically manage the service is that all portfolios are bespoke, so we don't insist that every portfolio is the same, and that I think distinguishes us from many of our competitors. But we build a portfolio of 20 stocks, and there'll be the 20 stocks that appear to be the best value at the time we're putting the portfolios together. Typical yield in normal circumstances is about 3%, so not dissimilar from the wider all-share yield or the typical private client portfolio. As you would expect, we're trying to build a diversified portfolio to help spread the risk. And we like to try and produce a relatively defensive portfolio. So we're not necessarily looking to smash the lights out performance-wise. We're trying to build something that's relatively defensive and has a bit of downside protection as far as possible. And I'm sure many of you will be familiar with some of the bigger names on AIM, stocks like Fevertree or online retailers such as ASOS and Boohoo. They always tend to look too expensive to me, so I've generally shied away from them. And there are plenty of other companies below the radar that have delivered great returns over the years. They're kind of unsung heroes. Businesses like RWS, which is a support services business that provides patent translation and patent filing services for many technology and healthcare companies around the world, amongst others. Businesses like Strix, which produces kettle controls that stop your kettle boiling dry. They've got about a 50% market share around the world, growing steadily, and obviously everyone replaces their kettle every so often, so there's a good replacement market as well. Also businesses like Restore, which provides document storage facilities for people like the NHS, big insurance companies and banks, lawyers, etc., who have to store lots of documents almost forevermore in case they need to refer back to them. They also do electronic storage as well, but the main business is paper-based. So yeah, I mean, they're the type of businesses that I like, companies with repeatable revenue streams that make money and that are easy to understand. So next slide, please. And what have we been doing through this pandemic? Well, pretty much exactly the same as always, but doubling down, I guess, on the important aspects of balance sheets and liquidity of those companies. Make sure they've got plenty of cash to survive the crisis if they are seeing a downturn, or even, as some cases have experienced, a complete stoppage of their businesses. If you're a pub company like Young & Co, then clearly they've been shut for the last 3 months, although about to reopen again, which I'm certainly looking forward to. But lots of other companies have taken the opportunity to raise money in the crisis, including actually Young & Co. Last week they raised about £90 million, which they raised pretty easily, and it went down well with investors. So there's plenty of life still for companies that need to raise money or want to raise money to take advantage of opportunities. But there are plenty of companies that have actually been relatively unaffected by the situation. And others, because they're small and nimble, have been able to adapt much more easily than many of their larger competitors. I won't dwell on this slide either. I think Bruce has already touched on something very pretty similar, but it's essentially saying that if you invest 100,000 in an IHT portfolio, then clearly your estate is going to be 40% better off as long as you've survived the 2-year qualification period. So the benefits of this type of approach is that it is relatively simple, unlike, say, a trust or other legal structures. It's speedy. If you give away assets, normally you have to wait 7 years for them to fall outside your estate, generally speaking. With this, as we've heard, it's after 2 years, and it's flexible. So if the client's circumstances change, they can regain control of those assets, i.e. liquidate the portfolio and spend the money on something else, whether that's healthcare or whatever it may be. So it is very simple. Oh, yeah, and they retain control. So the key risks, of course, this is not a risk-free approach. AIM shares are high risk, and the risks that may involve our liquidity of the shares, price movements, and the volatility. So clearly everyone must be comfortable with those risks before going down this particular route. And there's another risk warning there. So I look forward to hearing your questions in a few minutes' time after Janet has done her bit.
Thank you, Andrew. My name is Janet Raeburn, and I am a partner in the family team here at Rix Kay, and I'm going to be talking to you about protecting your assets from a family law point of view, the arrangements and documentation that you can put in place when you are in a relationship to ensure that there is clarity regarding your financial affairs and to provide protection for yourself and your family. Now, it is becoming increasingly more common for couples to seek to formalise their affairs through a prenuptial agreement or a postnuptial agreement, or indeed through a cohabitation agreement. I am going to talk you through what these are and the difference between them. But firstly, why do couples seek to enter into such agreements? Now, a pre or postnuptial agreement or a cohabitation agreement can help provide parties with clarity and with certainty, clarify what assets belong to each of you, and where there's a joint asset, well, what share of that asset do you each own? It can determine, and this is the crucial reason why people enter into these documents, can determine what should happen to assets in the event of a separation, thus doing all that can be done to minimise acrimony and costs if a relationship were to break down. As part of this, couples do seek to, or may seek to, provide as far as is possible for the protection of certain assets, for certain assets to be ring-fenced, for example, any inheritance that has been received. And to ensure that, again, as far as is able, that any family members that need protection, such as children from a previous relationship, are accounted for properly. Now, I'll just move on to the next slide if I can, Scott. I'm firstly going to talk to you about nuptial agreements. So these are prenuptial agreements or postnuptial agreements. A nuptial agreement is used to regulate a couple's finances during a relationship, helping to clarify, as I said, what assets are, and can determine how assets should be dealt with in the event of a separation and divorce. They are used for those that are entering into a marriage or civil partnership, prenuptial agreements, and also by those who are already within those institutions who obtain a postnuptial agreement. In terms of what can go into such an agreement, the agreement itself will clarify what the assets are, who owns them, and indeed what should happen to each asset in the event of a separation, including savings, investments, businesses, pensions, income. Put in the protection as far as you can for assets that have been gifted or inherited or accrued prior to the relationship. The key when entering into the document and when considering what provision to make in relation to the assets is to ensure that the needs of everybody has been met. So the document can be used to make sure that everyone, if a relationship did break down, is catered for properly in terms of housing and income. So if I turn to the next slide, there is a lot of talk in the media about nuptial agreements when particularly a celebrity's relationship breaks down. When Jeff Bezos got divorced, a lot of the commentary was about the fact that he had been very wealthy but not put in place a nuptial agreement. Now, there's very few of us that were in the position of Jeff Bezos, but certainly these nuptial agreements can still be of great assistance. The big question I get asked, though, the one question above anything else is, well, how are they treated legally? What use can a nuptial agreement be to me? Now, the impact of a nuptial agreement does vary quite hugely depending on where you live. And just for the purposes of today and what I'm talking about, it is the treatment of such agreements within this jurisdiction, so the jurisdiction of England and Wales. I must first highlight that the court always retains the power to vary a financial arrangement contained within a nuptial agreement. The purpose of the court retaining this power is to prevent one party being held to an agreement which is palpably unfair or doesn't cater to the needs of the parties or any children. In light of that framework of the court retaining that power, there have been a number of decisions that have been made by the court that has developed the treatment of nuptial agreements. And on the slide there, you can see a quotation from a judgment in the case of Radmacher and Granatino, which states, "The court should give effect to a prenuptial agreement that is freely entered into by both parties with a full appreciation of the implications, unless in the circumstances prevailing, it would not be fair to hold the parties to their agreement." And breathe. And just for information, that's really quite a short sentence for a judge. They do tend to go on a little bit. And if you return to the next slide, we'll have a look at actually what does that mean? What does it mean for you and I if we're looking at entering into a nuptial agreement? Firstly, there is the requirement that the agreement is freely entered into. There can be no putting an agreement under the nose of somebody at the last minute. There's got to be no mistake, no misrepresentation, no pressure. Secondly, there's got to be an understanding of the implications by both parties. So they know actually what the impact of the agreement is going to be. This requires both parties to have sought independent advice and also to have fully disclosed their financial affairs to the other. So you know what assets are being talked about when you then enter into that agreement. And lastly, it's got to be fair in all the circumstances. It is important to point out that what is fair can change. Firstly, it differs what's fair for a young couple that have got minimal assets. It's very different to what's fair for an older couple that perhaps have already accrued assets or got children from a previous relationship. Not only that, but what is fair does change for a particular couple after a period of 20 years, the couple have got 3 children. The arrangement that they entered into at the beginning of their relationship doesn't particularly have a lot of relevance now. It's not particularly fair for them. That is why it is absolutely crucial that one enters into an agreement but then keeps it under regular review, particularly on certain life events such as the birth of a child or perhaps if somebody loses their employment. There has been a recommendation to reform the area of law, leading towards more enforceability of these type of agreements, provided they meet certain safeguards, and how this transpires remains to be seen. But although no agreement can override the power of the court, provided the agreement is entered into properly and is fair in all the circumstances, one can anticipate it being enforced or at the very least highly influential upon any settlement that is entered into. And I'll just turn to the next slide. Now, nuptial agreements are used for those that are getting married or entering into a civil partnership. And the law is quite different for those that are not married, those that we call cohabitees. There does remain a misconception that there exists common law marriages. surely after a period of time or after the birth of some children, there is a principle that assets are shared or some protection given. I'm afraid it's not the case, despite calls for legal changes and the fact that the cohabiting couple that aren't marrying or entering into a civil partnership is the fastest growing family type. Despite that, a cohabitee has no automatic right to financial protection. Just turning to the next slide. Where there are jointly owned assets, such as a property, it will need to be determined as to what share each have. And supporting cohabitation agreement, one can enter into a declaration of trust that's the two documents support one another, that does determine exactly what share of a property you each own. If assets are owned solely by one party, the other has no automatic right to claim against those assets. It can be costly to try and resolve this, and there may not be a guarantee of success. What this does also mean is that it can be more or less advantageous to enter into such an agreement depending on what side of the asset fence you sit. A cohabitation agreement, such as a nuptial agreement, can achieve those aims of regulating financial affairs during a relationship and determining what happens on separation. An agreement can give peace of mind and protection for both parties and children during their lifetimes, or in the event of a death or separation, supporting the terms of will, not superseding them. Now, I should point out here, and this would be a topic for another day, that if you have children and perhaps the other person has all the assets, there are claims that one can make separately in relation to and for the children. So turning to the next slide. Where there are assets such as properties and businesses, it is essential that the agreement is prepared in conjunction with other relevant documentation. I've already mentioned declarations of trust, which can specifically state how a jointly owned property is to be divided, or if a property is in the name of one person but another person is to have an interest in it. It's important also to consider whether other documentation is needed. If there's a business where you are both shareholders, do you have a proper shareholders agreement in place? Or do you own the business but your spouse does work for the business? If so, do you have and have you looked at having employment contracts in place? If you don't have these documents, it is advisable, whether or not you're entering into a nuptial agreement or cohabitation agreement, to actually make sure that you have reviewed the position and put in place the necessary paperwork. And turning on to the next slide. I've already mentioned the matter of reviewing, and I really cannot stress how important it is. The use of agreements, both nuptial and cohabitation agreement, coupled with documentation relating to a business or property, can provide substantial protection. The protection is continued by regular review of those documents, just to make sure they continue to reflect the circumstances that you're in. I should also point out that if you've got assets located abroad, one has to take advice about how any agreements and documentation drawn up in this jurisdiction are actually treated in the country where your asset sits. Nuptial agreements, for example, in some countries they're enforced in full, in some they're simply put aside and not considered, when looking at the matter of a settlement. So it's important to take advice there. This is very much a generalised overview of the principles in this area. Each specific set of circumstances would require tailored specialised advice. And if you've got any questions in relation to what I've talked about, then do submit your questions and I'll do my very best to answer them. And thank you for listening.
Thank you very much, Janet, and to all of our speakers this afternoon, Bruce and indeed Andrew. Really interesting talk from each of our speakers. And as I'm sure you can imagine, very wide subjects covered and only a brief glimpse into some of the issues. All of their details are on screen there. They'd all welcome your calls if you have anything to ask them, questions, or just want an informal chat about your own personal circumstances, then please do not hesitate to pick up the phone or drop them an email. Hope you enjoyed the webinar with us this afternoon, and we look forward to seeing you very soon. Thanks very much and goodbye.